The Department of Justice releasing its remaining documents from the Jeffrey Epstein investigation. Deputy Attorney General Todd Bland saying the records will be posted throughout the day, including more than 2,000 videos, more than 180,000 images. Some of the material so explicit you have to verify being an adult before you can actually access it.
Many of Epstein's survivors have been publicly pushing for years to have these documents come out, but it took a law passed with near unanimous support in Congress to finally bring these documents to light.
Victims of Mr. Epstein have gone through unspeakable pain, and there's nobody that should say anything differently. And I to the extent that there's frustration, I understand where that comes from, just from what we know about Mr. Epstein. I hope that the work that the men and women within this department have done over the past.
Tonight, we are looking at one of the largest document releases in modern Department of Justice history. Millions of pages tied to the Jeffrey Epstein investigation are now public. Videos, images, reports, interview summaries, internal memos, an enormous archive that, at first glance, appears to represent long-awaited transparency. For years, victims pushed for this moment. Lawmakers demanded disclosure. The public questioned what was being withheld, and now, after intense pressure, the files are out. But here's the key question. Is this the full truth, or just a version of it? Because while millions of pages are available to the public, fully unredacted files are being reviewed in secure settings by judges, investigators, and select members of Congress. Those versions contain names, details, and context that the public may never see in their entirety. That difference between what we see and what officials see is where this story truly begins. Reports indicate that within the released materials are allegations referencing President Donald Trump. The Department of Justice has acknowledged that some documents contain claims involving him, while also warning that certain allegations are unverified or potentially sensational in nature. That combination, acknowledgement and disclaimer, creates a complex situation. On one side, the existence of allegations in federal files is significant. On the other, the credibility of those claims is not automatically established simply because they appear in a record. So what does this really mean? It means the story is not about a headline, it's about process. It's about how evidence is reviewed, how redactions are applied, and how transparency is defined in a case involving powerful figures. And it means that while the public scrolls through redacted pages, legal authorities are examining something far more complete.
New NPR investigation reveals the Justice Department withheld portions of the Jeffrey Epstein files that contain allegations involving President Trump, including material tied to claims that Mr. Trump sexually abused a minor and that some pages mentioning him were removed from the public record. Democrats on the House Oversight Committee called that out today, saying the DOJ's withholding of information could amount to a crime.
The stakes rose dramatically when a federal judge intervened over what were described as serious redaction failures. Redactions are not optional in sensitive cases. They exist to protect victims, safeguard private information, and prevent harm. In a case as high-profile and traumatic as this one, accuracy in redaction is essential. But errors occurred. According to court proceedings, some protected information was not properly concealed, prompting complaints and forcing the judiciary to step in. The judge ordered corrections and publicly addressed the issue. That moment mattered for two reasons. First, it demonstrated that even at the highest levels, mistakes can happen in document handling. Second, it opened the door to a broader question. If protective redactions failed in some places, how confident should the public be in the rest of the process? Redactions can serve legitimate purposes. They can shield victims, they can preserve active investigations, they can protect national security, but they can also obscure accountability if applied excessively or inconsistently. That concern intensified when two members of Congress, one Republican and one Democrat, reviewed the full unredacted files in a secure setting. After doing so, both publicly suggested that multiple powerful individuals may be shielded by over-redaction. This is not a minor detail. When lawmakers from opposing parties independently review classified material and reach similar conclusions, it signals that their concerns are not rooted in partisan politics, but in what they personally observed. They did not publicly name anyone. They are bound by classification rules. But they made clear that what the public sees is not identical to what they saw, and that gap matters. Because in the legal system, unredacted evidence carries weight whether the public sees it or not. Judges do not rely on press releases. Prosecutors do not build cases from headlines. They rely on complete records, names intact, timelines connected, context preserved. If material inside those files supports further investigation, it can influence legal decisions regardless of public visibility. Now let's talk about President Trump specifically. The Department of Justice has confirmed that some documents include allegations involving him. It is also stated that many claims could not be verified and may consist of second or third-hand accounts. That distinction is crucial. An allegation inside an investigative file is not the same as a proven fact. Federal agencies often document claims regardless of ultimate credibility. Compiling information does not equal endorsing it. At the same time, the existence of those claims within official records means they are subject to review, and review means scrutiny. As of now, no new charges have been announced in connection to this document release. There has been no formal indictment tied directly to these specific disclosures. But legal processes unfold quietly. Grand jury materials are secret. Judicial reviews occur behind closed doors. Motions are filed under seal. High-profile cases often move in ways the public does not immediately see. So when people ask whether this release places anyone in legal jeopardy, the honest answer is uncertainty. Uncertainty does not imply guilt. It does not predict prosecution. But it does reflect the reality that the full scope of review is not public. Beyond individual names, the broader issue remains systemic. The Epstein case has always involved a network, individuals connected by wealth, influence, travel, and access. That network spans years and crosses political, business, and social lines. In cases involving powerful circles, transparency becomes complicated. Legal caution increases. Political consequences loom large. Institutional reputations are at stake. That is why the integrity of the redaction process matters so much. If redactions are perceived as protecting influence rather than victims, trust erodes. If disclaimers appear vague, skepticism grows. And when bipartisan lawmakers publicly question transparency, scrutiny intensifies. Public trust depends not only on justice being done, but on justice being visible. Right now, there is a visible imbalance between what officials review privately and what the public reviews online. That imbalance fuels debate. It is important, however, to separate verified fact from speculation. Verified facts. Millions of pages have been released. A judge intervened over redaction errors. Lawmakers reviewed unredacted files and expressed concern about potential over-redaction. The Department of Justice acknowledged that some documents contain allegations involving President Trump while cautioning that many claims are unverified. Beyond that, conclusions require evidence. High-profile investigations often move slowly. They involve layers of review, procedural safeguards, and legal standards that do not operate on a 24-hour news cycle. So what happens next? Possibilities include continued judicial oversight of document handling, congressional pressure for greater transparency, additional disclosures if deemed appropriate, or legal action if evidence meets prosecutorial standards. It is equally possible that review concludes without new charges tied to these materials. The key takeaway is this: the document release is not the end of the story. It is a phase marked by scrutiny of process, debate over transparency, and ongoing legal evaluation. For President Trump, the situation remains legally undefined. Allegations exist in records. Federal authorities have cataloged claims. Judges are reviewing unredacted materials. But no new legal determination has been announced in connection to this release. In democratic systems, due process governs outcomes, not speculation. At the same time, transparency influences public confidence. When information gaps persist, questions persist. And when powerful names appear in investigative archives, attention follows. Ultimately, this case underscores a larger principle. Accountability in cases involving influence must be handled with both fairness and rigor. Fairness means not treating allegations as convictions. Rigor means not ignoring credible evidence if it exists. The coming months will reveal whether this document release leads to further action, additional oversight, or simply deeper public examination. For now, what we know is clear. Millions of pages are public. Some information remains redacted. Unredacted files are under review by those with authority, and the intersection of law, politics, and public trust is once again under a spotlight. This is not about one headline. It is about the integrity of institutions. And in cases involving power, integrity is everything.